Chapter 9. Defenses to Enforcement. Introduction. This chapter examines the defenses absent parents raise most frequently in their attempts to avoid enforcement of support orders. Chapters 5, 6, and 10 discuss defenses raised to prevent the establishment of an order and defenses peculiar to interstate cases. The following defenses are discussed: inability to pay, termination of parental rights, custody and visitation interference, release agreements, waiver by acquiescence, laches, and other equitable defenses, payment by alternative method, non-paternity, statutes of limitation, emancipation, death of obligor, bankruptcy, property exempt from execution, challenges to the state's authority to enforce the order, and attacks on the validity of the support order due to lack of personal jurisdiction. Most defenses to enforcement of child support orders have been held valid in at least some states. Especially as to the equitable defenses, the appellate decisions make it clear that each ruling is made in light of the circumstances of each particular case. An appellate court most likely will give great deference to the trial court's ruling, unless the law is clear. Where the law is not clear, decisions from other states in cases with similar facts can be instructive. Many of the cases cited in this chapter contain good public policy discussions, some as dicta. State appellate courts are increasingly supportive of the child support enforcement program and are overturning outdated decisions in the child support enforcement area. Where a trial court normally would feel compelled to follow a long line of musty common law, recent moves by a majority of other states can sway appellate courts. More important, the Child Support Enforcement Amendments of 1984 will markedly diminish the effectiveness of many defenses, at least at the enforcement stage. Once states comply with the 1984 amendments, income withholding will be the remedy of choice, both for intrastate and interstate cases. The 1984 amendments severely limit the obligor's defenses in the context of income withholding proceedings. That is not to say that the defenses will disappear entirely. Defense counsels are sure to find strategies to continue to make the arguments discussed in this chapter, most probably in support of motions for modification. Thus, the case law cited in this chapter should continue to be relevant. Inability to pay. Inability to pay is a frequent defense to a collection action based on the obligor's alleged lack of means to support himself or herself adequately and still comply with the support order. As treated here, the defense does not suggest active or passive avoidance of the duty to support. In most states, an obligor's financial straits may limit the effectiveness of coercive or criminal remedies, particularly contempt of court. To the contrary, inability to pay is not generally an effective defense against remedies directed at specific property. Inability to pay as an enforcement defense should not be synonymous with inability to pay as a basis for retroactive modification in states that allow such modifications. The court should not, sua sponte, modify, prospectively or retroactively, a support order based on a finding of the obligor's inability to pay made during the course of an enforcement proceeding. Ideally, the obligor should be required to file a proper motion for such relief and give the obligee notice and an opportunity to defend the motion, whether in a separate proceeding or simultaneously with the enforcement action. Civil contempt. An obligor may be incarcerated for civil contempt for willfully failing and refusing to comply with a court order for child support. This remedy is coercive in nature. The court must find that the obligor has the present ability to comply with the order or has a capability of performing some other task, for example, execution of income assignment, seeking work, enrolling in a drug or alcohol rehabilitation program. However, he or she must have refused to meet the purgation requirement before jail may be imposed. If the obligor was financially unable to comply with the support order at the time the arrearage accrued but has assets available to satisfy the arrearages at the time of the contempt hearing, the court may find him or her in contempt for a present refusal to apply the assets to the arrearages. If the obligor was able to pay the support when it fell due, but has no funds from which the obligation can be paid at the time of the hearing on contempt, the court may make a contempt finding. However, the court may not impose incarceration as a means of coercing the obligor into compliance, since he or she would not have the present ability to purge himself or herself. Generally, in civil contempt actions, the court has ordered the obligor to show cause why he or she should not be held in contempt for non-compliance, placing the burden on the obligor to prove present inability to pay and that this inability is not due to his or her fault or negligence. Faircloth v. Faircloth, 339 So 2d 650. Flat. 1976. Some courts have gone so far as to impose on the obligor additional burdens when an inability to pay defense is raised. For example, in Ex parte Hennig, 559 SW2D 401, text.sif.app. 1977, the court held that the obligor could be required to show that he had no real or personal property that could be sold, that attempts at borrowing had been made and were unsuccessful, with particulars, and that the obligor knew of no other source, including relatives, from whom he could borrow the funds to satisfy the support obligation. Similarly, in Dawson v. Dawson, 453 So 2D 1054, Alabama.sif.app. 1984, the court stated that merely being unemployed and having no cash is inadequate proof of inability to pay. In that case, the obligor recently had been awarded considerable assets by the divorce judgment that were unaccounted for at the contempt hearing. The court concluded that they still should be available for satisfying the child support delinquency. If the obligor placed himself or herself in a position of being financially unable to comply with the support order and the court finds the acts of the obligor to be in contumacious disregard of the court's order, the obligor may be held in contempt. Generally, however, the obligor cannot be incarcerated for civil contempt, again because he or she would not have the keys to the jailhouse. An exception could occur when the court has imposed a purgation requirement other than payment of money and the obligor has refused to perform. Criminal contempt. Some courts have stated that criminal contempt proceedings may become appropriate when a person commits chronic violations of a court order, single violations of which constitute civil contempt. In those cases, the repeated violations constituted blatant contumacy. National Popsicle Corporation v. Kroll, 104 F2D 259, 260, CA2 1939. A judgment of criminal contempt is punitive rather than coercive in nature. Criminal contempt is defined as conduct that tends to impair the authority of the court. For this reason, the obligee need not show them the obligor has the present ability to meet the obligation, and a criminal sentence, rather than a purgation requirement, is imposed. In Murray v. Murray, 587 P2D 1220, Hawaii 1978, the Supreme Court of Hawaii determined that an obligor could be sentenced for criminal contempt for willfully violating the terms of a support order, even though, at the time of the hearing, he or she did not have the present ability to comply with the order or to pay the arrearages. The court pointed out, however, that when criminal sanctions are imposed, all statutory, procedural, and due process requirements must be followed strictly. Remedies directed against specific property. An absent parent's prior or present inability to pay child support generally is not a successful defense to actions directed at specific assets of the absent parent, such as garnishment of wages or levy and execution on real or personal property. In the majority of states, past due support installments become vested as judgments in favor of the obligee immediately on default in payment, and the courts have no power to give retrospective application to a modification. In these states, the obligor must seek prospective modification of the support order at the time his or her change in circumstances makes it impossible to meet the support obligation. In jurisdictions requiring the arrearages to be reduced to judgment before collection action may be directed against property, many courts allow the absent parent to argue for equitable relief justifying retroactive modification based on his prior inability to pay the ordered amount of support. Welser v. Welser, 149 A2D 814, N.J.App.diff. 1959. In these instances, the defense arises in the obligee's action to obtain judgment on the arrearages, which may be combined with a request for attachment of the obligor's property. Once the judgment is obtained, however, the obligor is stopped from collaterally attacking it in the future in a subsequent action against property. The Supreme Court of Lower, in remarriage of Veternak, 334 NW2D 761, Lower 1983, adopted novel approach to a father's argument that his child support payments should be reduced because of his inability to pay while he was incarcerated. In upholding the trial court's application of the father's equity in the marital home to the child support obligation, the court noted that inability to pay has become less a consideration while a long-range capacity to earn money has become more of a consideration. Also, in this case the court implied that the father's incarceration was a voluntary diminishing of his earning capacity. Termination of parental rights. A parent's legal relations with his or her child may be terminated by reason of abuse or abandonment of the child or after consent to the child's adoption. A final decree of adoption terminates all legal relations between the adopted child and his or her natural parent or parents. Upon adoption, all unvested legal rights between the adopted child and his or her biological parents are absolutely terminated, and the natural parents are relieved of all future duties and obligations, including support, with respect to the child. However, if an obligor's child support arrearages have been reduced to money judgment or have attained such status by operation of law, the right to such payments becomes vested, and the debt is not affected by the adoption. C. V. R. 404A2D 366, NJ 1979. The accrued arrearages represent monies due pursuant to a valid judgment ordering payments for the support and benefit of the minor child. such arrearages are still due and owing and have not been eradicated by the adoption decree. Sample v. Petrolsky, 313 SE2D 145, GA.app. 1984. Adoptions involving minor children whose natural parents are living require parental consent, unless the parent-child relationship already has been terminated on other grounds, such as abuse, neglect, or abandonment, or that termination would be in the children's best interests. In interest of Goethe, 311 NW2D 104, lower 1981, frequently, in exchange for a consent to the adoption, the custodial parent agrees to waive the right to collect accrued child support arrearages. Rogers v. Rogers, 505 SW2D 138, Mo.app. 1974. In most states, the custodial parent has the legal authority to bargain away the arrearages as consideration for the consent, which is viewed as a simple contractual agreement. However, since a custodial parent generally lacks authority to bargain away current or future support, the agreement may not purport to waive support due between the signing of the agreement and the final adoption order. Rogers, Supra, at p. 145. When the adoption does not take place, the natural parent remains responsible for support of the child. In Rogers, Supra, the consent of the father was obtained but the final adoption decree was never entered. The natural father had discontinued child support payments but had not been notified of the failure to finalize the adoption. The mother, on seeking collection of arrears, was held to have acquiesced in the father's failure to make child support payments as they became due and thereby waived the right to enforce these payments. However, the appellate court reinstated the father's duty to pay support in the future. When parental rights are terminated for neglect, non-support, or other reasons not directly connected with an adoption proceeding, and the child becomes a ward of the state, the parental obligation of support is not always terminated automatically. Classification of a minor as a ward of the state is not a sufficient basis for automatically reducing child support. While a child committed to the care and custody of the state may no longer in fact depend on parental support, dependence is not the measure of parental obligation. Patzikont v. Patzikont, 644 P2D 1009, Can. App. 1982. However, in Department of Human Resources v. Vine, 662 P2D 295, Nevada 1983, the mother obtained sole parental rights, and the state 4D agency was unable to reimpose a support obligation on the father after the mother applied for public assistance. Custody and visitation interference. The general rule is that visitation and child support are separate, not interdependent issues. Thus, a refusal of visitation by the custodial parent does not relieve the absent parent of his or her child support obligation. Thomas v. Thomas, 335 SW2D 827, Tennessee. 1960, Williams v. Williams, 143 SC2D 443, GA.app. 1965. The primary consideration is the best interest of the child in whom both visitation and support rights reside. For an analysis of the case law on a court's authority to cancel or modify arrears, to refuse to enforce arrear, to suspend future support payments, or to set up a trust fund on the child, Ren's behalf when the custodial parent denies visitation privileges in violation of a court order or separation agreement. See 95 AL 2D 118. Another annotation at 804 TH 1231 discusses cases in which the custodial parent violates a clear judicial prohibition against removing the child, Ren, from specified geographical boundaries and the resulting authority of the court to terminate, suspend, or reduce child support payments. Substantial portions of the Uniform Marriage and Divorce Act, UMDA, have been adopted in 8 states and selected portions in many more. A provision of the Act states, in part, that if a party fails to comply with a provision of a decree or temporary order, the obligation of the other party to make payments for support or to permit visitation is not suspended, but he or she may move the court to grant an appropriate order. UMDA, 9 AULA seconds 315. There are few interpretive decisions, but 2 Illinois courts have held that the appropriate remedy for a father who has been denied visitation is to move the court for contempt against the mother and possibly a change of custody in the appropriate circumstances. Huckabee v. Huckabee, 393 NE2D 1256, 3 App. 1979, People X Roll. Winger v. Young, 397 NE2D 253, 3 App. 1979. Release agreements. Generally, An agreement between the parents of a child made outside the courtroom that purports to absolve the absent parent of the support obligation is invalid. 100 Al 3D 1129. Regardless of agreements or disagreements between parents, children are entitled to continuing support in accordance with their needs and the parent's ability to provide for them. The amount of support required and the ability of each parent to provide such support are questions that rest primarily with the trial court. Flynn v. Flynn, 604 SW2D 785, Mo.App. 1980. Nevertheless, such agreements occasionally form the basis of a defense. They can be express attempts at accord and satisfaction or implied as a result of a reconciliation between the parents. Accord and satisfaction. An accord is a contract to discharge an existing cause of action, tort, or contract. Satisfaction is the performance of such contract. In the context of child support arrearages, accord and satisfaction can be defined as an agreement between the absent parent and the custodial parent relieving the absent parent of past due child support payments, either in exchange for some other valid consideration or if supported by the requisite donative intent. The most significant distinction in determining the validity of agreements is between past due support and future payments. Arrearages have been held to represent a debt due the obligee for prior care given the child, REN, and, therefore, may be negotiable. In Anderson v. Anderson, 407 P2D 304, Idaho 1965, the court examined an agreement releasing the father from past due support and reducing future support in exchange for a $600 lump sum payment and a set of carpenter's tools. The agreement as to the arrearages was upheld, but the court held that the mother could not release the father permanently from his duty to provide future child support. It remained within the exclusive province of the court to modify its support orders. Extending the concept further to include arrears, numerous cases support the proposition that any agreement between former spouses purporting to release the absent parent from the support obligation as ordered by the court is void, as against public policy. The general principle is that parents by agreement cannot nullify a court's order so as to deprive a minor child of the support granted in the decree. 100 Al 3D 1129, seconds 4, c. pp. 1149 to 1153. In some instances, courts have invalidated agreements between parents on the ground of insufficient consideration. For example, in Herb v. Herb, 103 NW2D 361, Lower 1960, the court held that there was no consideration for an agreement to reduce the decreed child support payments from $30 per week to $70 per month. According to the ruling, the custodial parent gained nothing she was not already entitled to receive, and the absent parent did not obligate himself to do anything he was not already required to do. Similarly, in McCabe v. McCabe, 167 NE2D 364, Ohio App. 1959, the court held as unenforceable the obligor's agreement to make up back support payments and give consent for the wife's present husband to adopt in exchange for a release of his future obligation, because he was bound by law to pay the support arrearages and the adoption did not go through. In State Ex Rel. Hansen v. Mackay, 571 P2D 166, or.app. 1977, the court found that a gratuitous satisfaction of judgment by a mother who had assigned her support rights to the Oregon 4D agency had no effect on the agency's right to enforce the judgment. Remarriage of absent and custodial parents. According to the Illinois Court of Appeals, 4th District, in Ringstrom v. Ringstrom, 428 NE2D 743, 1981, the vast weight of authority holds that the remarriage of the parties to each other annuls the prior divorce decree and restores the parties to their respective rights as if they had never been divorced. Therefore, the mother may not seek later to collect arrearages that accrued under the order for support contained in the first divorce decree. It is questionable whether this rule would be applied to support arrears that had been assigned to a state 4D agency prior to remarriage. As noted in Green v. Toa District Court, 312 NW2D 915. Lower 1981, a valid assignment of a support judgment gives the assignee rights that cannot be affected by the assignee without the assignee's consent. In Green, the court followed decisions from Georgia and Nebraska in holding that the remarriage of the parents does not automatically vacate a judgment for accrued support installments, nor does it deprive the divorce court of subject matter jurisdiction to enforce the obligation as to those unpaid installments. Temporary reconciliation. Courts generally have held that the temporary reconciliation of the mother and father while the divorce is pending or subsequent to the divorce does not nullify or abate the child support order. In Scully v. Scully, 331 NW2D 801, Neb. 1983, the court stated that there was no authority to reduce past due installments for child support and that the father remained liable for $11,700 in unpaid child support for a period in which the mother and children resided in his home. The court admitted that in some circumstances the principle of equitable estoppel would preclude collection, based on grounds of public policy and good faith. Circumstances would require good faith reliance on statements or conduct of the party to be estopped and a change of position to his detriment by the party claiming estoppel. Waiver by acquiescence, laches, and other equitable defenses. Waiver by acquiescence and laches are similar defenses. Black's Law Dictionary defines laches as a failure to assert a claim within a proper time, while acquiescence implies knowing assent on which another relies. In regard to child support enforcement, 5 Al 4th 1015 defines laches as a delay in seeking recovery of arrearages of court-awarded child support. It is ordinarily a defense to such recovery only when it is shown that the custodial parent's delay in seeking recovery prejudiced the absent parent. Papcun v. Papcun, 436 A2D 282, Connecticut 1980. Held that prejudice was not established because the absent parent had not changed his circumstances in reliance on the custodial parent's 9-year delay in failing to collect payments. When prejudice is established, as in Anthony v. Anthony, 204 NW 2D 829, lower 1973, where the wife delayed 17 years in pursuing her right to collect child support, the deciding factor was the absent parent's reliance on her delay, which led him to believe she intended to waive or abandon recovery. Laches in this case was held to be a valid defense. Laches may be a partial defense, as demonstrated by Accrued v. Gardner, 257 A2D 174, MD.App. 1969. Laches was held to constitute a partial bar to an attempt by a divorced wife to obtain a judgment for arrearages in alimony and child support that were approximately 13 years past due. The divorced wife had waited too long to recover arrearage payments meant to cover current support obligations. The court awarded arrearages for only 3 years prior to the filing of the petition. Another view is that the doctrine of laches has no application to child support obligations. Fitzgerald v. Fitzgerald, 618 P2D 867, Montana 1980. Under a divorce decree, the liability of a parent for child support payments should be unaffected by the laches of the other parent in seeking enforcement of the child's rights. Proceedings to enforce support judgments are equitable in nature, and a mother may not be found to have waived her child's right to receive support from its father by failing to promptly enforce it. Armour v. Allen, 377 So 2D 798, Flap. App. 1979. The defense of waiver by acquiescence implies the obligee's knowing waiver to non-payment or partial payment of child support. Material prejudice is not always a requirement of estoppel by acquiescence. Davidson v. Van Lengen, 266 NW 2D 436, 5 Al 4th 1001, lower 1978. However, there must be substantial evidence that the custodial parent had intended to waive back child support. Sheffields v. Strickland, 599 SW2D 422, Arc.App. 1980, also notes that laches, estoppel, and statutes of limitation are affirmative defenses to a petition to reduce arrears to judgment and must be pleaded affirmatively. If the evidence does not support the obligor's contention that there was an agreement to reduce or waive child support payments, then the obligee will not be held to have acquiesced. Lewis v. Lewis, 256 NE 2D 660, 3 App. 1970. In Remarriage of Herman, 466 NE 2D 1289, 1984, the First District Illinois Court of Appeals stated that the defense of equitable estoppel must be proved by clear and unequivocal evidence. Equitable estoppel arises when the voluntary conduct of the obligee results in good faith detrimental reliance by the obligor and an unwarranted benefit to the obligee. The court in Herman noted that cases which have found equitable estoppel have involved egregious circumstances. In State Ex Rel. Division of Family Services v. Willig, 613 SW2D 705, Mo. App. 1981. The mother testified she had not entered into written or verbal agreement with the father that he not pay child support. She admitted requesting public assistance because she did not expect to receive any child support from the father. The court found insufficient evidence to support the finding that the former wife had acquiesced in her former husband's non-payment of child support for the 5-year period preceding her assignment of support rights to the state. The court's determining factor was that taxpayers, through AFDC, were providing the support the husband owed, and that his testimony that he had been contacted several times by the welfare department belied any contention of waiver by acquiescence. On the other hand, the same Missouri court later found, in State Ex Rel. Division of Family Services v. Rubel, SW2D, Mo.App. ed. 48498, the 22nd of January 1985, that, by virtue of two written agreements with the father to modify the support order, the mother had acquiesced to reduced payments. The agreements had been filed with the court, but the court heard no motion to modify support and was not tasked to approve the agreements. Nevertheless, when the mother assigned her support rights to the state as a condition of eligibility for AFDC, the state was deemed to have received an assignment of the mother's legal right to receive support as specified by the original decree and not pursuant to the agreements. Further, the state was not estopped by a misrepresentation of its agents, who, over a period of more than 6 years, had instructed the father to pay child support in accordance with the filed agreements, rather than with the original decree. The state was allowed to recover the full amount due under the court order from the date of the mother's assignment of support rights. Payment the alternative method. Generally, as a matter of law, an obligor should not be allowed credit for expenditures made while the child is in his or her custody, or for other voluntary payments made on behalf of the child that do not conform specifically to the terms of the decree. Credit for voluntary payments permits the absent parent to vary the terms of the decree and usurps the custodial parent's right to determine the manner in which support money will be spent. Hirschfield v. Hirschfield, 347 NW2D 627, Wisconsin.App. 1984, Horn v. Horn, 239 NE2D 348, NY App. 1968, Glover v. Glover, 598 SW2D 736, ARC. 1980. In determining whether credit against arrearages should be granted for non-conforming payments, the rule may hinge on whether or not the arrearages become automatic judgments as they accrue. Where support arrearages vest automatically as judgments, it is generally held that no credit may be given for non-conforming payments. To do so would be to grant a retroactive modification. Fearon v. Fearon, 154 SE2D 165, VA. 1967, if, as in Cope and Cope, 619 P2D 883, or 1980. It was decided that statute bars retroactive modification of accrued installments because they have ripened into judgments. They become unmodifiable and no credit will be given. In this case, a father's Social Security benefits paid directly to the mother for the benefit of the child could not be credited retroactively against the father's child support obligation. See also Fowler v. Fowler, 244 A2D 375, Connecticut. 1968, and Chase v. Chase, 444 P2D 145, Wash. 1968, for decisions on the court's refusal to grant credit toward child support arrears for Social Security disability payments made to the child, Wren. However, New Hampshire and Mississippi courts have followed Alabama, Arkansas, Georgia, Kansas, Massachusetts, Nebraska, New Mexico, and Tennessee in allowing a husband credit toward his overdue support obligation for Social Security payments made to the ex-wife for the benefit of the children. Griffin v. Avery, 424 A2D 175, NH 1980, Needham v. Needham, 420 SO2D 1072, Miss. 1982, 77 L3D 1315. Perhaps due to the harshness of the general rule, some courts have been willing to consider equitable principles where compulsory circumstances led to the substituted form of payment. Where the custodial parent expressly or by implication consents to accept an alternate form of payment as partial or complete satisfaction under the decree, some courts will give credit if the payment is in substantial compliance with the spirit and intent of the support decree. Williams v. Williams, 405 SO2D 1277, La.App. 1981, Whitman v. Whitman, 405 NE2D 608, Indiana. App. 1980. Credit also has been allowed where the father took custody of the children because of illness or incompetency of the mother. Silas v. Silas, 300 SO2D 522, La.App. 1974. Liefring v. Liefring, 622 SW2D 519, Mo.App. 1981, Headley v. Headley, 172 SO2D 29, Alabama. 1964, White v. White, 368A2D 1061, MD.App. 1977. The credit for cash payments of gifts given directly to the child, educational expenses, or food, clothing, medical expenses, or other necessities depends to a large degree on the circumstances of each individual case. Humrick v. Seward, 189 SC2D 882, GA.App. 1972, Remarriage of Joke-Lund, 410 NE2D 890, 3 App. 1980, Gould v. Awapara, 365 SW2D 671, Tex. Sif. App. 1963. Credit for support given by the non-custodial parent during periods of extended visitation or temporary custody usually is not permitted unless it is so provided in the decree. Escott v. Escott, 325 NE2D 395, 3 App. 1975, Atkins v. Zachary, 254 SE2D 837, Georgia 1979, in Tuck v. Tuck, 316 NW2D 304, Neb. 1982, the stipulation that support would abate during the 6-week visitation period was incorporated into the decree, and the absent parent was not held responsible during that period. There is some precedent for allowing credit for support given during these periods. 47 Al 3D 1031, James v. James, 271 Say 2D 151, Georgia 1980, noted that the non-custodial parent is not the only one obligated to support the child and ordered the custodial father to pay $15 per day for each day the couple's children visited with the mother. The courts also have upheld agreements to reduce support payments during the summer when children spend substantial amounts of time with the non-custodial parent. Khan v. Khan, 532 P2D 541, Arizona.App. 1975. Non-Paternity. An absent father often will claim that after his marriage to the mother was dissolved he discovered he was not the natural father of a child conceived or born during or before the marriage. Courts differ on the effects of a paternity finding or an implication of non-parentage in a divorce decree. The doctrine of res judicata would prohibit later litigation of a matter on which final judgment was reached. As long as one of the parties is not guilty of fraud or collusion, the father normally would be collaterally estopped from relitigating material facts and questions that were directly in issue in an original divorce or support proceeding. In some cases, the doctrine of res judicata extends to incidental questions arising in the previous action, so that a final judgment on matters essentially connected with the subject matter in earlier litigation may be conclusive. Under this broad concept of res judicata, most courts have found that a father and mother are bound by a finding or implication of paternity in a divorce or support proceeding. However, a child or a stranger who was not a party to the earlier proceeding is not bound by the court's determination. Courts that have considered the binding effect on a father of an order entered in divorce or support proceeding are divided as to whether the paternity issue must have been raised and litigated in the original action. Decisions from almost every state are reported in the annotation at 78 Al 3D 846. In a similar vein is the decision in Re Johnson, 152 calories.rptr. 121, 88 calories.app.3D 848, 1979. Relying on Clevenger v. Clevenger, 189 calories.app.2D 258, 1961, the court held that the husband was estopped from asserting illegitimacy in a support proceeding, even though the parties had stipulated that he was not the father of a child born 10 days prior to the parties' marriage. The court based its reasoning on facts indicating that the husband represented himself to the child as his father, that the husband intended for the child to accept and act on this representation, and that the child relied on the representation in ignorance of the true facts. Statutes of limitation. Statutes of limitation prevent the assertion of claims that have become stale. State statutes vary from 5 to 20 years in which judgment creditors must act to enforce judgments before they become dormant. Normally, a judgment may be revived by a writ of sine faces. See discussion in Chapter 8. Supra. A normal money judgment is based on a fixed amount and does not accrue any new or additional rights from the date of rendition. However, a child's right to support is ongoing until the child reaches majority. At the time a child support order is issued, it is not a judgment of a sum then due, like most awards, but rather a variable sum that increases as each installment is unpaid. State Ex Rel. Stanhope v. Pratt, 533 SW2D 563, Mo. 1976. Given the installment nature of a support order, a majority of jurisdictions have ruled that the statute of limitation does not begin to run until each installment becomes due, rather than at the time the order is issued. 70 Alb 2D 1250, 1258, Treaster v. Laird, 519 P2D 1231, Cullow. 1974, Bruce v. Phoebe, 488 P2D 662, Arizona. 1971, Kuhn v. Kuhn, 313 P2D 369, Wash. 1957, Britain v. Britain, 671 P2D 1135, NM 1983. Several courts have disallowed statutes of limitation entirely, because a judgment for child support is a continuing judgment and always subject to modification by the court. V. Miller, 46 NW 2D 618, Nib. 1950. In Nipfer v. Buller, 35 NW 2D 425, Minnesota. 1948. The Minnesota court held that the statutory period does not begin to run until the children reach majority and all payments are due. In states where each unpaid child support installment is not automatically a part of a judgment, an independent action for judgment may be brought within the appropriate statutory period after the child attains majority. In Croager v. Croager, 353 NW 2D 60, Wisconsin. App. 1984. The court held that the obligee had 20 years after the daughter reached the age of majority to bring an independent action for judgment. However, in Griffin v. Avery, 424 A2D 175, NH 1980, the court applied the 6-year limitation applicable to personal actions, rather than the 20-year limit on actions on judgments, since the unpaid installments were not judgments. Most statutes of limitation contain tolling provisions, such as the defendant's absence from the state, the minority of the plaintiff, a written acknowledgement or promise by the defendant to pay the debt, and sometimes a payment on the debt or acknowledgement on the court record of partial satisfaction of the debt. Emancipation. The obligation of parents to support their children ordinarily ceases on the children's reaching the age of majority or on the children's emancipation. Cordonez v. Cordonez, 215 P2D 32, California. 1950, Neeson v. Neeson, 157 NW 2D 660, Wisconsin. 1968, 32 Al 3D 1057, the emancipation of a minor child frees the child from parental control. At the same time, the child surrenders his or her right to maintenance and support from his or her parents. Bierman v. Bierman, 584 SW 2D 106, Mo.App. 1979. Thus, the courts are not required to establish or enforce support orders for any minor child who has become self-supporting, emancipated, or married or who has ceased to attend school after the applicable age of majority. In Re Miller, 660 P2D 205, or.App. 1983, a parent's liability to support terminates when the child is in no way dependent on him or her for support. Wood v. Wood, 61 So 2D 436, Alabama. 1952, in Remarriage of Fetters, 585 P2D 104, Col.App. 1978, Iskeith v. Iskeith, 250 NIS 2D 481, UFT. 203 NE 2D 925, NYCT.App. 1964, the problem most often arises in determining whether an absent parent is entitled to relief from further payments under an existing support order. The defense that the child has become emancipated does not automatically relieve the parent of a support obligation. Tormer v. Tormer, 645 P2D 395, Montana. 1982, in making such a determination, the courts have considered the circumstances of the particular case. Generally, they have ruled that the emancipation of a minor does not relieve the parent from the support order when the minor is not capable of supporting himself or herself. Allison v. Binkley, 259 SW2D 511, Arc. 1953, in Camp v. Camp, 640 P2D 48, Wyoming. 1982. The absent parent was held liable for support of his disabled child despite the child's reaching the age of majority. The court construed the support statute to mean all children, not just minor children. The fact that children are working to aid in their support when the absent parent fails to make payments as required by decree does not necessarily relieve the parent of the obligation to comply with the order for support. Waldron v. Waldron, 301 NE2D 167, 3 App. 1973, Taylor v. Taylor, 412 So 2D 1231, Alabama.app. 1982, the annotation at 32 Al 3D 1055 discusses acts initiated by a minor that may have the effect of terminating a support obligation, for example, employment, name change, refusal to visit parent. With regard to the parent's obligation to support the child, REN, between the ages of 18 and 21, the opinion is mixed, with many jurisdictions ruling that emancipation has no relevancy to the parent's obligation to finance the child's schooling between those ages. Miller v. Miller, Supra. Support orders that predate the law declaring the age of majority to be 18 continue to be obligatory to age 21. Carrick v. Carrick, 605 P2D 1215, or.app. 1980, a child may become unemancipated during his or her minority. In Fetters, Supra. The Colorado Court of Appeals found that when the daughter's marriage was annulled, the father's support obligation under the divorce decree was reinstated. The daughter was 16 and living with and dependent on her mother for support. The question frequently arises whether an obligor may make a pro rata reduction of a court-ordered obligation on the emancipation of one child, when the order does not specify a certain amount to be paid per child. In a case of first impression, the Supreme Court of Montana held in Torma v. Torma, 645 P2D 395, 1982, that a decree ordering the father to pay support of $125 per month for 2 children required continuation of the entire monthly support payment until the younger child attained majority. The court approved the rationale of courts in Colorado, Maryland, Oregon, and Connecticut, and noted this position to be the rule in the vast majority of states. The court quoted from Becker v. Becker, 387 A2D 317, 320, MD.app. 1978. The reason for considering a single amount to be paid periodically for the support of more than one child as not subject to an automatic pro rata reduction is twofold. First, a child support order is not based solely on the needs of the minor children but takes into account what the parent can afford to pay. Citations omitted. Consequently, a child support order may not accurately reflect what the children actually require but only what the parent can reasonably be expected to pay. To allow an automatic reduction of an undivided order would be to ignore the realities of such a situation. Second, to regard an undivided child support order as equally divisible among the children is to ignore the fact that the requirements of the individual children may vary widely, depending on the circumstances. Cooper v. Matheny, 349 P2D 812, 813, or 1960. Delivet v. Delivet, 156 Connecticut. 1, 238 A2D 402, 404, Connecticut. 1968. On the other hand, in Patzicont v. Patzicont, 644 P2D 1009, Can. App. 1982, the court held that lump sum orders may be reduced proportionately without modification upon death, majority, or change of custody to another parent. Interestingly, the Kansas court also pointed out that emancipation, including marriage, does not necessarily terminate the obligation of support, as dependency is not a measure of parental responsibility in Kansas. Death of obligor. At common law, the father's obligation to support his child terminated simultaneously with his death. 18 Alt 2D 1126. When there is an order to make payments for support of a child, the order terminates automatically with respect to payments that would become due after such death, unless the court has ordered that those payments shall not be affected by the parent's death. Gordon v. Valley National Bank, 492 P2D 444, Arizona. App. 1972, in appropriate circumstances, a court may enter a child support order which survives the death of the father. If a judicial decree for child support is to be held to impose upon a parent a greater duty of support than that required by common law, the decree must state specifically that such obligation is to survive the death of the obligor. Scudder v. Scudder, 348 P2D 225, Wash. 1960, the court, in Spencer v. Spencer, 87 NW2D 212, Nebraska 1957, based its ruling that the support obligation survived the obligor's death on the fact that the decree specifically provides that child support payments will remain in force until the children shall become of age or self-supporting, or until the further order of the court, and, thus, survive against his estate. Although liability for support generally terminates upon the death of the obligor, parents may agree to extend that liability beyond death. If the terms of the agreement are incorporated into an interlocutory decree for divorce, there is a proper basis for a claim against the estate of the parent. Belser v. Belser, 2 rptr. 259, 177 p2d 228, cal.app. 1960 states that, by statute or agreement between parents, allow support orders to continue to be enforceable against the absent parent's estate after death are likewise enforceable for arrearages that accrued before death. In Re Cirillo's estate, 114 List 2d 799, NY 1952, in Re Weaver's estate, 122 NE 2d 599, 3 App. 1954. In those states having adopted UMDO in its entirety, the statute provides that death of a spouse terminates a maintenance obligation, but not a support obligation. UMDO, 9 AULA seconds 316, B, C, 201 floor 000500006. In some states, the statute does not contain the provision excluding termination of support. Therefore, unless otherwise agreed in writing or expressly provided in the decree, provisions for the support of a child are terminated by emancipation of the child or death of either party. Bush L.V. Sep. 613 SW2D 689, Mo.App. 1981. Bankruptcy. Many absent parents seek relief from their financial obligations in the U.S. bankruptcy courts. Typically, such actions are filed under Chapter 7 of the Bankruptcy Code, straight bankruptcy, or Chapter 13, wage earner plans. In the former, the relief sought is discharge from all dischargeable debts. In the latter, the debtor is seeking the protection and guidance of a bankruptcy trustee in devising and carrying out a plan to pay back all debts gradually. Either type of proceeding can have a significant effect, both positive and negative, on the collection of child support. Debtor's responsibilities. In addition to providing notice to all affected creditors, the debtor is required to file a schedule of his or her assets, liabilities, and exempt property. A provision of the Bankruptcy Code allows the debtor to select a portion of his or her property as exempt from the claims of creditors. 11 U.S.C. 522d. The Code further provides that state law may determine these exemptions and supersede the Code provision. Many states have taken advantage of this authority, and state exemption laws often provide the obligor less protection from child support claims than from the claims of other creditors. See, for example, seconds 452.120 RSMO, sup. Thus, there may exist a pool of identified assets which may be seized to collect support arrearages during or after the bankruptcy proceeding. Automatic stay. By virtue of 11 U.S.C. 362a, creditors generally are prohibited from taking any actions to establish or collect debts while the debtor's bankruptcy proceeding is pending. This stay arises automatically upon the filing of the bankruptcy petition. To the extent that it prevents the collection of child support obligations, the stay can create time-consuming litigation. In Chapter 7 proceedings, the length of time between the debtor's filing the petition in bankruptcy and the granting of the discharge is short, 3-4 months, after which collection action for the non-dischargeable child support debt may proceed. Unfortunately, because of difficulties faced by State 4D agencies in receiving and reacting properly to notices of filing, the agency occasionally will take action against an absent parent in ignorance of a pending bankruptcy proceeding. This also can be a problem with actions that take a number of months to complete, such as outstanding arrest warrants and tax refund interceptions. An exemption to the automatic stay does not make a support collection action immune from injunction. As the House Judiciary Report under 11 USC 362 declares, the bankruptcy courts have ample powers to stay actions not covered by the automatic stay. When an action is accepted from the automatic stay, the trustee must move the court into action, rather than requiring the creditor to move for relief from the stay. In this way, the court determines on a case-by-case basis whether or not to stay a particular action. As a result, the 4D agency occasionally finds itself in an adversary proceeding in bankruptcy court. 11 U.S.C. 362b provides that the filing of a petition under Chapter 7 does not operate as a stay for collection of alimony, maintenance, or support from property that is not property of the estate. Property of the estate includes all of the debtor's assets, but excludes exempt U.S. property and the wages the debtor earns while the bankruptcy proceeding is pending. This is not true in Chapter 13 cases. As a result, it could be argued that a wage garnishment or income withholding order for child support issued while a Chapter 7 bankruptcy is pending should not be stayed. Another effective argument hinges on public policy. Section 456 (b) of the Social Security Act, 42 U.S.C. 656 (b) states that child support obligations that have been assigned to states pursuant to Title 4 (d) are not dischargeable in bankruptcy. See below for a discussion of the dischargeability issue. This language suggests a congressional declaration that enforcing a parent's child support obligation is more important to society than providing that parent with a totally fresh financial start. Bankruptcy courts rightfully guard their authority to enforce the stay. The stay is necessary to allow the bankruptcy court to sort out the financial condition of the debtor, to distribute the available assets equitably among the creditors according to law, and to protect the debtor from claims against his exempt property. These are laudable provisions, designed to protect both the debtor and his family. The public policy statement, which also appears in the Code at 11 U.S.C. 523-5, indicates that the aims of the 4D program may be paramount. Dischargeability. At 42 U.S.C. 656, b, the Social Services Amendments of 1974, PL 93 647, prohibited the discharge in bankruptcy of child support arrearages that an obligee assigned to a state as a condition of AFDC eligibility. That provision was repealed by the 1978 Bankruptcy Code, PL 95 598, effective October 1, 1979, which contained a broader provision providing that child support obligations were not dischargeable where owed to a spouse, former spouse, or child. In connection with a separation agreement, divorce decree, or property agreement, but not the extent that such debt is assigned to another entity, voluntarily, by operation of law, or otherwise. 11 U.S.C. 523-5, The 1978 amendment caused numerous problems for the child support enforcement program. The first was the exception that allowed assigned child support obligations to be discharged. The second was the language contained in the rule of non-dischargeability itself, which limits application of the rule to support obligations in connection with a separation agreement, divorce decree, or property settlement. Since many orders established by 4D agencies do not meet these criteria, for example, orders entered in paternity proceedings brought by the agency, it has been argued that they are dischargeable. This argument would seem to apply with equal force to orders entered in ERASA proceedings and orders entered in state court proceedings that are not merged into the divorce proceedings. Congress corrected the situation in the Omnibus Budget Reconciliation Act of 1981 by reenacting 42 U.S.C. 656, b, and amending 11 U.S.C. 523-a, 5a. The new version of the lattice section creates an exception to the exception to the exception by providing that assigned support obligations that have been assigned as a condition for eligibility for public assistance are again non-dischargeable. The 1981 amendments did not change that language in 11 U.S.C. 523-a, 5a, which limits non-dischargeability to obligations created in connection with a separation agreement, divorce decree, or property agreement. However, this language was changed by the Bankruptcy Amendments and Federal Judgeship Act of 1984. 11 U.S.C. 523-5, now provides that debts in connection with an order of a court of record that are assigned to the federal government or to a state or any political subdivision of such state are non-dischargeable. The effective date of the change was October 8, 1984. One important issue remains: does the change in law affect those absent parents who filed petitions in bankruptcy during the period in which all assigned child support arrearages were dischargeable? In matter of Reynolds, 726 F2D 1420, CA 9 1984, the Ninth Circuit U.S. Court of Appeals held that the change in law applied to actions that were pending in bankruptcy court when the change in law occurred. The court found a congressional intent for such a holding in the 1981 Act's language, which made the amendments dealing with dischargeability effective immediately on enactment, August 13, 1981. Property exempt from execution. Many states have laws that make homestead items, which are exempt from execution by general creditors, subject to execution for collection of child support. See, for example, Seconds 452.140 RSMO, 1978. Some courts are willing to create such an exception without statutory support. Although Nevada law does not contain a provision like this, the Nevada Supreme Court had an opportunity to examine the applicability of that state's homestead exemptions in a mother's action to collect approximately $90,000 in child support arrearages that had accrued under an Indiana order. After the mother recorded her Indiana judgment in Nevada, the father filed a homestead exemption on his home. Pursuant to Nevada law, the mother moved to have the exemption ruled inapplicable. On appeal, the Nevada High Court ruled that to protect the father's second family at the expense of depriving his first family of the support to which it is entitled was clearly not the Nevada legislature's intent in enacting the homestead exemption. The dissenting justice suggested that the legislature should be charged with enacting specific exceptions to the homestead exemption. Breedlove v. Breedlove, 691 P2D 426. Nevada 1984. Other courts have refused to create exceptions. The Louisiana Supreme Court, in Thibodex v. Thibodex, 454 So 2D 813, La. 1984, applied the anti-attachment provision of the Federal Longshoremen's and Harbor Workers' Compensation Act to prohibit the custodial parent from garnishing the absent parent's disability benefits for overdue child support. See also Putz v. Putz, 572 P2D 970, Oklahoma 1977. Challenges to states' authority. Many state constitutions prohibit legislative grants of public money, property, or credit to private persons. However, these provisions often make specific exceptions for grants of public assistance to the needy. Two state Supreme Courts have addressed defenses raised by obligors that statutes authorizing state officials to bring child support collection actions on behalf of non-AFDC obligees violate such constitutional provisions. In both Johnson v. Johnson, 634 P2D 877, Wash. 1981, and Leet v. Leet, 624 SW2D 21, Mo. 1981, the High Courts held that the state statutes authorizing support enforcement services on behalf of families who are not receiving public assistance further the compelling public interests of safeguarding children's constitutional rights, protecting the taxpayers from additional public assistance expenditures, and assuring that the primary child support obligation falls on the parents. Both courts held the constitutional provisions inapplicable due to these overriding public purposes. Stating similar reasons, the Florida Supreme Court, in Florida Department of Health and Rehabilitative Services v. Heffler, 382 So 2D 301, Flat. 1980, held that a statute allowing the state to provide child support collection and paternity determination services to unwed mothers who are not receiving public assistance does not violate the equal protection guarantee of the state constitution. In another light, the Oregon Court of Appeals addressed the authority of the state 4D agency to collect child support arrearages that accrued prior to the effective date of the state statute requiring AFDC applicants to assign their support rights. In Butchko v. Butchko, 602 P2D 672, or 1979, the court held that the assignment statute was remedial and did not affect the obligor's substantive rights and that the assignment included both prospective and accrued unpaid support. The state was entitled to enforce collection of assigned support regardless of whether the support accrued or the AFDC was given prior to the effective date of the statute. In State Ex Rel. Williams v. Williams, 647 SW2D 590, Mo.App. 1983. The Missouri Court of Appeals found that the obligor did not have standing to challenge the validity or authenticity of the obligee's assignment of support rights. Validity of the support order. If the rendering court did not have personal jurisdiction over the absent parent at the time the child support order was entered, the obligor will attack the validity of the support order. Personal jurisdiction may have been obtained by consent, voluntary entry of appearance, personal service within the state, or long-arm jurisdiction based on the absent parent's minimum contacts sufficient to meet the due process test as enunciated in International Shoe Company v. State of Washington, 326 U.S. 310, 1945. As the court found in Morton v. U.S., 708 F2D 680, Kafk 1983. Personal jurisdiction over a serviceman residing in Alaska was not obtained by the Alabama Divorce Court based on his prior residence there and his having filed 2 state income tax returns in Alabama. The U.S. Court of Appeals declared that the obligor was not domiciled in Alabama, nor did he reside in or have sufficient contacts with the state at the time the divorce court attempted to obtain personal jurisdiction. Therefore, the money judgment rendered by the Alabama court was void and could not be enforced.